Good morning, everyone, and welcome to today's webinar, Guides to Insolvency Law Changes. Today, our panel will outline the key changes to insolvency law and the implications for unsecured creditors. They will also discuss the relationship between declining economic activity and insolvency rates. On our panel today, we have Tom Ahmad, Director of Bailey Ahmad Business Recovery, Prav Reddy, Partner at Katten, and ECA's Director of Legal and Business, Rob Driscoll. Now, today's webinar will include a Q&A. You'll find a questions panel on your screen now. Do please make sure that you use this throughout today's presentation if you have a question. I'll be monitoring these and our panelists will answer as many as possible at the end of the session. Finally, our viewers are reminded that a full replay of today's webinar, as well as replays of the entire ECA webinar series, are available on ECA's YouTube channel at youtube.com/ECA Live. And for more information and ECA guidance for members and the wider industry as well on everything related to business recovery, visit www.eca.co.uk/business-recovery. And with that, I will hand over to our first presenter, Rob. I will just switch to the presentation.
Thank you, Omar, and welcome back, everybody. As Omar said, we're delighted to be able to deliver this webinar with Bailey Ahmad and Katten, that's Tom and Prav. So you can take me through to the next slide. I'm just going to set the scene for everybody before we dive into the technical expertise. So if we can move on a slide. You'll have heard me on previous webinars talk about the kind of economic output for the industry. And at the moment, we have we had in April the Office of Budget Responsibility setting out that they expected a sharp decline and then an automatic recovery in a V-shaped recession. That was way back when, really, if you think back to March, we as an economy expected that we would depart the office and be back in a couple of weeks. Well, we're now sitting here 7 months later, and the industry and the world is a very different place. So what I wanted to set out for you is what that activity would look like. There has been a sharp crash, and in July, August, there does appear to be some level of recovery. I want to remind you all that construction was never told to stop. Other businesses, other sectors, hospitality, travel, were worse off because they just stopped overnight and have a very, very slow recovery rate. Clients may have individually chosen to stop activity, whether at their convenience or for safety reasons or for otherwise. But in the main, government told construction, Alok Sharma specifically thanked construction as a business secretary minister for continuing to stay strong. What we've got here in terms of the industrial construction output, therefore, is a sharp crash and then some kind of recovery. If we move on to the next slide, I'll just depict a little bit of different sectoral outputs. So if you were in commercial, the sharp drop overall was around 35%. Now that was massive. It was the biggest, even worse than the financial crash or World War I and II and the Spanish flu epidemic back in the early 1900s. If we can move to the next slide. What we've got is actually seeing the worst crash is in private house building. You've got the marker there for where the Help to Buy arrangement kicks in. But really, most economists will tell you that Help to Buy arrangements might continue support for first-time buyers, but house prices, specifically in London, which everybody in the country always tends to assume is overpriced in the first place, had started to stagnate and drop pre-COVID-19, maybe as a result of the Brexit decision, but nevertheless, others would say perhaps they couldn't keep rising at that rate anyway. But they had started to drop. Now, London tends to be a leader for the rest of the country by a number of months. So it would have indicated that the rest of the country would have started to stagnate eventually on housing anyway. There has, in the intervening period of COVID-19, been a sharp demand to get those housing transactions through. but that may not sustain itself within first-time buyers given the rising level of unemployment as the furlough system starts to taper off. If we can move through to the next slide. Now, the best sector in terms of performance has been infrastructure, and traditionally in recessions, as the market crashes, the public sector spend has been counter-cyclical. That was not the case in the last recession because there wasn't the public spending available. We have just come out of an austerity period. We are, and this is probably a personal opinion, in an age of politics where policy is very much driven by voter demand and headline politics, and therefore we're currently seeing big announcements from Boris and his government around infrastructure spend and commitments to those spends. However, the truth is always as and when that spend lands. Does it land fast enough to keep up with the industry? The other thing I'd ask you to note is that while activity stops immediately, we are currently running in a period where we will mainly be existing on pre-COVID contracts, i.e. contracts which were priced and entered into prior to COVID-19 hitting the market. What happens is, as you move through to your tendering opportunities that you're currently bidding for, they may be reduced opportunities, longer tender lists, and therefore the market gets more competitive. People will go in for jobs at a loss and undercut the market, which means maintaining profit can be very hard. If we move through to the next slide, just on the last one, private housing and RMI, that's repair, maintenance and improvement, had a sharp drop as well because there was a stigma around inviting people into your home in a COVID secure way. We would say that our health and safety team have got that. There is plenty of guidance out there from government and from ECA on how to have trades in your home in a fairly COVID secure way to continue. There is also an opinion from certain quarters that the consumer savings that have been put in place if you haven't had your employment jeopardized may have allowed you to actually increase spend on your home and improvements in that area. So if we move through to the next area, just to give people a real picture of what happened to the workforce. Now, most of construction's 3.1 million people tends to be site-based. Hence, we would expect the large number of people to be working at their usual workplace because their usual or normal workplace is on site, whichever site that may be at the time. Construction in this sense includes FM. On furlough, a whopping 28%. From a business perspective, it has been said to me, why wouldn't you furlough if you can get cash into the business to help sustain it through 2020 and stave off some of the crisis you might be facing? Working remotely, I guess you're looking at your office staff, which may only account for 25%, a quarter of your entire business, even less in some cases. So it makes sense again that the amount of working remotely would be seen as a small margin. If we move on, so I just wanted to focus on the rise because not everything's bad in the industry. So June 2020 versus May 2020, we're actually seeing a bounce back. The question really is how quickly and how sustainable can that be? You've heard from us at ECA about the Construction Leadership Council, which is the conduit for government to industry, talk about its Restart, Reset, Reinvent 3-year recovery program for the industry. And that's what this is about, trying to get early demand delivered as soon as possible to get the cash into the industry before we have capability and capacity problems. So what we've got is private housing seems to have bounced back. We have a number of commercial issues bouncing back, but there is some reticence in certain areas and certain geographical locations because of the local lockdown issues. If we move through to the last part, I'll then let the guys take over. What I wanted to say is the time lag. I outlined earlier that there is a lag between the contracts you're in, which may be pre-COVID, to the opportunities you're tendering for, which will be post or during COVID. You've heard from ECA about the work we've done with government and CLC to create future-proofing clauses in contracts so that you're de-risking the business of the impact of delays and disruption costs, which could seriously undermine your business models. These figures are only Q1, I believe, for 2020. So they actually predate COVID in many ways. Construction is the top of the charts for the level of insolvencies, and there's a number of issues around that. It's a high-risk industry as it is, never mind COVID-19. If we go into the final slide for me, I'll then hand over. So just running down some of those issues, we've got the risk of rising interest rates, although some would say that would be madness in this point within the economy. But at some point, given that we're near nothing, there may need to be some level of rise. Infrastructure spend, we do have a commitment in terms of political rhetoric, so we've just got to see that actually materialises on the ground in projects and fast enough to sustain the industry through the crash. Overpopulation in the market. It has been cited by many insolvency professionals, reports and commentators that part of the problem for construction. We have 301,000 businesses, 99% are SMEs in this market. That means every opportunity in an industry which averages 4 to 5 levels of supply chain deep has a number of tenderers looking for the one opportunity. And we know that when markets crash, people look for security like retentions, performance bonds, parent company guarantees, which can also commercially asphyxiate the business from operating properly. But they look for that security in addition sometimes to a decent trading record and history, which can dampen down opportunities for newer companies. On the back of this, lest we not forget there, I put a bullet there, C19 and Brexit, that we've got Brexit around the corner in 2021, which a couple of years back, I was doing a lot of information about how the top 4 out of 5 materials imported and exported out of the UK for construction, all related to M&E. Specifically, I think 3 out of the 4 were electrical. And you couple that with an ageing skills crisis and potential EU exit of some of the labour force upon which we rely. My colleagues in the employment team would say it's not so bad in the electrotechnical sector because we need a skilled, competent workforce, and most of the EU labour tended to sit within the unskilled area, but we'll remain to see what the impact is on that. So in terms of the perfect storm, you could have a couple of major crises hitting the industry within an 18-month period. VAT can also be a problem when it comes to cash flow and solvency of businesses, as repayments have to be made. We're all going to switch to a March 2020 VAT reverse charging system, whereby you don't even get, if you're in the supply chain, the VAT in the first place. So the overdraft from government upon which we relied, and some contractors would rely for their cash flow, will be missing. But if you are large materials buyers, you may also end up becoming trying to move from quarterly to monthly repayment trader, the term used for a contractor who asks HMRC to pay their VAT back on the materials they buy when they're not receiving their VAT from their clients. House builders do a lot of that. So you may end up giving the government a permanent overdraft in the fact that they will be paying you back on a continuing basis. Construction companies, low capital assets, in my experience, a lot of you that are owner managers of businesses may own the premises yourself and lease it back to the business, various other parts of it. Like we know from the Carillion debacle in 2017 that there are large amounts of work in progress, and auditors and others are very, very reticent now about the habit which brought Carillion down, which was counting work in progress as definitive income. And then there are perceivably large debts within the construction industry. I think the final thing for me as a lawyer, mediator, and director of business at ECA is principally we exist on a pay-as-you-go system. We get paid monthly in most construction contracts or maintenance contracts in arrears for the work we've done in terms of labour and materials. The longer that cash flow window is from spending money on labour and materials before the end of the month, which is installed, and then we can start counting the legislative days to payment, which there are still people who practice the age-old Carillion 120 days. And then we get a final account system that budges in behind that and says all interim payments were on account only, and we can now change those payments and try and claw back if we want to bring our margins back in time. So it's a hard market, but what I would say is these guys, if anything, are the best to advise you on what these changes to insolvency law are. My initial view on this was, wow, there are some permanent changes here. There were some temporary ones came in. Some of them were helpful. I think there's a lot of help there if you are a debtor who is struggling, but the realistic picture will be given by both Tom and Prav. But I worry also that because we are a number of creditors always looking for payment down the supply chain, that there might be a bit of harm to creditors in this. So without further ado, Tom.
Thanks, Rob. That's a really good introduction. I think we are all dealing with a challenging environment, and hopefully some of the information that Prav and I are going to share will be useful. If we could go to the next slide. Just to give you a bit of an overview, we haven't got a great deal of time, but what Prav and I are going to cover together is just a bit of a recap on insolvency, the need of getting advice early, and what the existing solutions are before moving and spending much of the detail on the new Corporate Insolvency and Governance Act, Prav discussing implications, especially in terms of contracts and the like, and also reflecting on directors' duties throughout this really challenging period where directors are trying to make some pretty tough decisions under a lot of pressure with unprecedented uncertainty and an ever-changing position week by week, day by day, with some time for Q&A. So without further ado, if we can go to the next slide, please. So when we talk about insolvency, and I know this might be sucking eggs a bit, but I think it's really important just to be clear on that. What do we mean? There's a balance sheet measure that assets are less than liabilities, but often what the more critical measure is for a lot of businesses is this cash flow insolvency, an inability to pay debts as they fall due. And for a lot of businesses, ultimately, coronavirus has had such a significant impact on an ability to generate income. And that really has put pressure on the whole economy. And there's been a number of interventions, including these provisions, to try and alleviate some of that pressure or manage it. If we can move to the next slide, please. And one thing I just want to stress in this very short overview is that if you are affected in any way, I would urge you to seek advice, whether it's directly or indirectly, whether you're someone that's owed money or struggling to pay, and go to those that are qualified to either advise you or point you in the right direction, your accountant, a solicitor, a licensed insolvency practitioner, and make sure they're regulated and qualified. And with all of these things, the earlier you seek advice, the more options are available, and you can move from being very reactive, which I think most people feel, even on an emotional level at the moment they're doing, to being as proactive as possible. And also, whatever solution is put in place, there's proper support. So let's get into the detail. If we can go to the next slide, please. So, when we, Prav and I, are looking at supporting a company that's in difficulty, what are we trying to do? Well, we're looking often, and it's the director's wishes, to save the company, the business, its assets in an intact way. And that's often the first step. If we can't do that, we tend to move to, well, okay, we can't save the company, the legal entity, the LLP. Can we save elements of the business or the trading business within it and its asset? And often that is through a process of moving it to another entity, and you're protecting jobs, you're increasing as much value as you can, customers get projects completed, and that can be a good second place if you can't save the company. And if that's not possible, what do we do next? Well, we are looking at avoiding a situation where continuing to trade a business that isn't viable opens up the suppliers and creditors to a potential worsening of their situation. So we need to think about when and how should we cease to trade and manage a structured wind down so that we can facilitate a restart and a moving forward for everyone, but stopping things getting worse. And that tends to be how I certainly approach my thinking when advising businesses. So if we go to the next slide, please. So I'm just going to quickly talk through those scenarios to give a sense of the types of solutions that already exist to some extent for saving a company. And these include things like, restructuring whilst you're trading, looking at refinancing, restructuring. We're going back to that. You might be looking at, making some redundancies, thinking differently about how you operate as a business, looking at your pricing, all of those sorts of things that you can do on a day-to-day basis, and potentially in a rather informal way internally, raising new finance, and again, informal negotiations with key creditors. Certainly HMRC at the moment are offering time to pay, and if they were one of your major creditors and you've got that breathing space, you can do that without the need of a formal insolvency process. You can also then move on to a second tier. There's a new interim moratorium, which I'll talk about later in more detail, and that's part of the new insolvency changes that we're seeing. But there's a procedure that's called a company voluntary arrangement, where a company essentially offers a deal to its creditors to repay them over time, allowing the company and its business to remain intact, often as a result of an event that's affected the company that they've rectified. So it could have been, for example, in the case of coronavirus, a catastrophic impact on an ability to trade for a period, but they need a long period to now, going forward, it's a viable business. They need some additional time to repay debts, and they can do that through this structured deal. It may well be administration, which is a process that a lot of people hear about in the media, essentially a protection put around a company whilst an insolvency practitioner takes control of the company's affairs with a view to trying to get the best possible outcome and a better outcome than, say, liquidation or a ceasing to trade of the company. So those are some of the processes that are in place to save a company. If we can move to the next slide, please. If we can't save a company, what can we do to save a business as a going concern? And that might be the business and assets as a working unit or an element of those. And administration tends to be the best solution for that at the present time, where there is a protection put around the company, and an administrator would look to sell businesses and assets as a going concern to another entity to protect jobs. And we've seen that a lot in the media. We might have a chain of restaurants where administrators appointed, they identify the aspects of the business, the sites that are still valuable, and they will look to sell those, protecting jobs, maintaining supply relationships, and getting the best out of a difficult situation. But often the amount recovered won't be sufficient to pay all the creditors in full, and therefore an insolvency practitioner is appointed. And that is also tied up with the concept of pre-packs, which for those that have been following the industry over time have had potentially a bit of a checkered reputation, but pre-pack means agreeing a deal in advance of a company entering into administration or insolvency process, and then it's the insolvency practitioner acting in a professional capacity completing the sale. That can be a challenging process when people feel that this has been done behind closed doors, but often it adds real value because there's substantial cost savings, and as long as there's full disclosure and an independent rigor in terms of dealing with the marketing and sales process in advance, you can get some great outcomes very quickly. If we can move forward to the next slide, please. And if we can't do the two previous, what can we do to avoid a worsening of position? And then again, liquidation is a process that we have in place that is a sort of an orderly winding up of a company's affairs, a structured cessation of trade where a company is insolvent. There's creditors voluntary liquidation, where I tend to lead in that we're dealing with proactive directors that make the decision. It's a sensible thing to do. And as insolvency practitioners, we advise them on that process. We advise them on how best to cease to trade and manage those creditor relationships, the redundancy processes, and avoiding making bad decisions near failure, which could expose both the directors and their creditors and stakeholders to harm. And it allows all those people that are involved to understand what the circumstances were and for them to move on. And we'll sell whatever assets remain for the benefit of creditors. And often that's important for directors and those affected to restart and move forward. And that's part of the insolvency market. You know, there is a bit of a recycling here that we are part of. Can we move to the next slide, please? Now, I've rattled through that really quickly, so I'm really conscious of that, but there is a video that I have previously done on YouTube, and that's a link to it that you can have a look at, and I spend a bit more time running through the existing insolvency solutions and the sorts of scenarios where they apply. But I want to spend much of this presentation moving on to the new insolvency provisions. So if we could move to that slide, please. So just to give a bit of background here, it normally takes 6 months for a bill to go through the House. This legislation went through, and I think about 6 weeks, which is unprecedented. And it was there that came into force on the 26th of June to provide targeted support for businesses and other entities that are really struggling in view of the coronavirus epidemic. And it's done that by making some temporary and permanent changes to insolvency and company law. And the aim overall is to provide flexibility and breathing space, in addition to all the fiscal measures that have already been implemented by government, with a view to, you know, mitigating the economic impact of this pandemic. So it includes a new company moratorium. It includes a prohibition on certain termination clauses, a new restructuring plan, some temporary provisions to avoid statutory demands and restrict winding up petitions, and a temporary suspension of wrongful trading. Now, in the following slides, I'm going to go through each one in a bit more detail. So if we can go to the next slide. So let's start with the new moratorium. So the new moratorium is a permanent change, and the aim is to give struggling businesses some breathing space to explore rescue and recovery options, and that free from the threat of creditor action. So it's available to businesses, which are companies or LLPs, registered in England, Wales, Scotland, and Northern Ireland. The company must be or likely to be insolvent. And so that goes back to my first sort of clarification right at the beginning of the seminar. But also critically, the company is likely to recover, and likely is more likely than not. So the moratorium shouldn't be there just to delay an inevitable failure of a company or another insolvency, enter into another insolvency process. It's really there for companies that are likely to be able to recover. So a good example might be, we've suffered a critical issue that means that the company can't meet its liabilities. Currently, they're under pressure, but the director is able to raise some finance, release some personal funds, sell some assets to repay those debts, and needs a period of time. And once it's done that and raised that money, it can pay the accumulated debts. So that's a good example where we've got fundamentally a good business, but it just needs some protection. Now, I just want to make a quick note on the ability of the likelihood of recovery. It's obviously very difficult to make those sorts of projections at the moment in view of the changing environment. So my understanding, and Prav might be able to confirm this, is that that particular requirement is relaxed until the 30th of September at the moment. So what does it do? It gives an initial 20 business days breathing space where creditors can't legally enforce their rights. That can be extended by another 20 business days to a total of 40 if agreed by creditors or the court. And what's different from other moratoriums is that in this process, the directors remain in control. Unlike administration, where an insolvency practitioner essentially takes over, here the directors remain in control, but the process is overseen by a new role. It's the role of a monitor, which must be a licensed insolvency practitioner. The monitor's role is to ensure the integrity of the moratorium process and ensure that the creditors' interests are protected. So if for example, if in the course of the moratorium it becomes clear that this isn't going to work, the process must end, and it's the monitor's role to do that. Now, this is pretty major infringement on creditors' rights, and I think that's something that Rob touched on earlier. So there are protections that are in there, and there's also a temporary small company exemption. And small companies are defined of there's 3 potential criteria, and if you satisfy 2, then you fall into that exemption. Your turnover must not be more than 2.8 million. Your balance sheet assets total not more than 1.4 million, or not more than 50 employees. But again, it's a new tool. It's potentially very useful for businesses that are fundamentally sound and just need a relatively short period to get through some significant cash flow pressure. Next slide, please. So termination clauses. So many supply contracts that business operate with will include termination clauses in the event that a company enters into an insolvency procedure. And that in itself can make a rescue of a company very, very difficult. Therefore, there's now suspension of such clauses if a company enters into an insolvency procedure, including this new moratorium that I've just mentioned. And it's a much broader change than what was already in place, where there was protection against essential supplies, which was a much narrower list of contracts that couldn't be terminated. So a good example might be, say, a food supplier where they're critical to the trade of a business, their accounts up to date, but the provisions included a termination clause. The company goes into administration, and the food supplier could just take the view they just didn't want to supply them anymore, which would make a recovery impossible. Can't do that anymore. There are protections for those creditors that might be unduly affected who can apply to court, but it just gives a bit more wriggle room for businesses or more scope for businesses to implement recovery plans. There are some exclusions, and one particular exclusion are financial institutions and various financial products. So for example, lending contracts. So there, in that scenario, I understand that it's no obligation for them to continue to supply finance, which is a shame, but you know, we're moving in the right direction here. So if we can move to the next slide, please. So for larger businesses, there is a new restructuring plan that's been put in place. It's very similar to a procedure called the Scheme of Arrangement, which already exists in the Companies Act. It's there for complex debt restructuring and also supporting the injection of finance. And the big change here is that in these large restructurings in the past, you could have a class of creditors that would be required to agree to the process, but would use their position to, I suppose, you know, negotiate a ransom. And here we have this new function. It's called the cross-class cram-down procedure that will bind a dissenting creditor if it can be proven that, you know, the restructuring plan won't unduly affect them when compared to the alternative. It brings us closer to an American-style recovery system. There are checks and balances with this. Again, it has to be sanctioned by the court as fair and equitable. As I said, it's likely to be used by large companies with complex debt arrangements. Can't see it being used in small company cases, largely because of the cost and the complexity associated with implementing that process. But for larger organizations, it could be a very useful tool. And if we can move to the next slide, please. Now, some of the temporary measures that we're seeing at the moment that are really had a real impact on certainly creditors' ability to recover their debts is avoiding of statutory demands from the period of between the 1st of March and the 30th of September. Again, winding up petitions, a restriction on doing that has been put into place again into the 30th of September, where COVID-19 has clearly been a factor in a business's inability to repay. So for creditors, this is huge. They're trying to recover money and they're just being stopped from doing so. So this is a big intervention for the government here, but it's a temporary one. Now, these temporary measures may well extend. The world continues to change. You know, who knows when furlough is going to stop or whether it will be extended. These things are still subject to debate, but as it stands at the moment, these are some key temporary measures that have had a massive impact on companies' ability to continue to trade. In addition, and something that's been mentioned quite a bit, is a suspension of wrongful trading provisions, or the wrongful trading provisions, until the 30th of September. I'm sure Prav will talk more about this shortly, but ultimately wrongful trading refers to trading a company, a director trading a company when they knew or ought to have known that the company was insolvent, and the result of that is that they've worsened the position to creditors. And the wrongful trading provisions are there so that in an insolvency event, directors could be made personally liable for that loss. So a real deterrent against bad behaviour. And the government felt, though, that for many companies, given the impact of COVID-19, there's such uncertainty and hardship that it's very hard for directors to really be clear on the ability to trade whilst solvent or insolvent, because the world's changing on a daily basis. So they felt that they needed to ease this restriction so that directors were more confident to trade and put their best effort behind a company to try and recover. So there is there is a restriction for that period, or it's a suspension for that period, but all the other directors' duties remain, and there are many of them. So directors do need to be mindful of their obligations to act in the interests of the company and its creditors. And that's the point at which I will hand over to Prav, because this is where he will take over and explain a bit more about that, as well as the implications from a contractual basis. Over to you, Prav.
Thank you, Tom. So as Tom mentioned, the Corporate Insolvency and Governance Act 2020 came into force on the 26th of June 2020. So in addition to the reforms that Tom touched on, the Act extends the prohibition on the termination of contracts by reason of insolvency. And these are known as ipso facto clauses. And as Rob mentioned earlier, these reforms have been seen as debtor friendly, but it's obviously important that creditors and all companies know their position. Put simply, ipso facto clauses apply on the occurrence of an insolvency event or on the potential insolvency of one party. They will either seek to terminate the contract as an event of default has arisen, or try to seek to impose altered terms arising from a default. And the evolution of these ipso facto clauses in UK insolvency has arisen from the need to protect an insolvent company becoming vulnerable to ransom creditors, either holding out for payment of arrears or threatening loss of supply, and that the operation of these clauses can therefore undermine any rescue efforts, and if supply is lost, potentially prevent a company from remaining an operational entity, depreciating any value in the company. And the reason for the slow evolution for the interference of ipso facto clauses has been the court's desire to protect the freedom of contracts between parties. As a result of that, the reforms have been limited and incremental over a number of years. Prior to the recent reforms, the only restrictions were for insolvency-related terms in contracts for the supply of essential goods or services, being gas, electricity, communication services, and certain other identified electronic supplies such as Wi-Fi and chip-and-pin devices. And this was introduced by Section 233 of the Insolvency Act, which applies to all forms of insolvency, and through its various gradual amendments, essentially Section 233 provides supplier of essential goods and services can ask for the payment of, can ask for a personal guarantee from an administrator or liquidator for the payment of ongoing services, but cannot demand payment of pre-insolvency arrears as a condition of that future supply. And this was designed to prevent suppliers from holding liquidators or administrators to ransom and trying to elevate their position above other creditors by receiving priority payments. In 2015, the provisions were extended to introduce Section 233A of the Insolvency Act, which only applied to administrations or company voluntary arrangements, which are both rescue procedures. And this extended the provisions to provide that an insolvency-related term of a contract for the supply of essential goods or services would cease to have effect. And it also extended provisions in contracts that would terminate or allow for any other thing to take place or do any other thing. And this would therefore capture seeking to impose altered terms in the contract, such as payment terms, and it also included to seek to an ability to seek to terminate in respect of a pre-insolvency breach as well. The carve-outs under Section 233A allowing a supplier to terminate would be with the consent of the supervisor or administrator, or with the court's permission, or if charges for post-insolvency supply are not paid within 28 days of them becoming due. In terms of the test for hardship, and I'll deal with this in a bit more detail shortly, would be that the continuation of the contract would cause the supplier hardship, and this is obviously a factual test. Another basis would also be if the administrator or supervisor of a CVA failed to provide the personal guarantee within 14 days of a written request. The provisions of Section 233A only applies to contracts that were entered into after the 1st of October 2015. And one of the problems in relation to those provisions were that it was only largely restricted to utilities and electronic supplies and ignored the fact that there were other essential supplies to allow the continued operations of companies that were not in the Section 233 list. Also, suppliers were protected by this ability to demand this personal guarantee from the office holder for post-insolvency charges, but it was thought by the industry that this may impact on longer-term rescues or restructuring strategies, particularly where there was immediate liquidity problems. And there was further reform in 2016, which expanded the scope of Section 233 and 233A, which essentially allowed an administrator or a supervisor to designate as essential any of its suppliers by filing a notice with the court. Now, all of those provisions continue to apply, but the recent amendments under the Corporate Insolvency and Governance Act have introduced a new Section 233B into the Insolvency Act 1986, and it has much more far-reaching amendments than previous. If you could move on to the next slide, please. The first major change is that the provisions apply to any existing insolvency procedure under the Insolvency Act. So it would now include liquidations, not be restricted to administrations and CVAs, so any insolvency process, including the new procedures introduced under the Act, moratoriums and restructuring plans, and applied to any insolvency process from the 26th of June 2020 when the Act came into force. The second major change is that Section 233B is not restricted to essential goods or services or supplies, but applies to any contract for the supply of goods or services. It's not as far-reaching as the US provisions, which apply to any contracts, but it has been extended from the previous provisions. In similar terms to Section 233A, it also contains a blanket prohibition of any automatic or elective termination clauses continuing to have effect, when a company becomes subject to a relevant insolvency procedure. Again, this would extend to a contract providing for termination for any other thing that would take place or to do any other thing, and again prevents the supplier to terminate because of an event occurring before the insolvency event. It also continues the restriction on making payment of pre-insolvency arrears as a condition for continued supply. In contrast to section 233A, the office holder is no longer required to provide a personal guarantee for ongoing costs. Such costs would rank as an expense, which is an elevated status of priority in an insolvency payment waterfall in the insolvent estate, and would be payable in full during the moratorium period. The same carve-outs apply, which are office holder consent or company consent or court permission, where the hardship test would be applied. In addition, and just to show the changing nature of this legislation and the need to be adaptable, there's an introduction of a section 233C, where the government retains the power to amend the provisions either to exclude any of the insolvency procedures or to exclude certain kinds of company, supplier, contract, goods or services from the list. And the exclusions under section 233B are three. Essential suppliers that already fall within section 233A. Those apply to administrations and company voluntary arrangements, and also provide the suppliers with the personal guarantee from the office holders. In addition, a number of financial services companies and banks, and the list is set out in a schedule in the Insolvency Act. And thirdly, there's a temporary exclusion for small suppliers, which applies at the moment to companies with a turnover of less than 10.2 million or fewer than 50 employees. These exclusions are intended to stay in effect until 30th of September 2020, but it's understood they'll be extended until April 2021. Next slide, please. In addition, next slide, please, sorry. In addition to the requirement to provide services or supplies to the insolvent company, the amendments also include the prohibition on any other thing. This is likely to lead to disputes as to the meaning and effect of clauses in certain contracts. On the face of it, this would apply to seeking to alter payment terms or even switching to payment on delivery. The prohibition also would catch pre-insolvency breaches before the start of the insolvency period. Questionable whether this would relate to non-payment related breaches. Would it include events such as willful default or fraud? I think these issues will have to be developed with case law over time. And then also the application of the hardship test. The question will be whether the court will adopt a balancing act, as they do with other forms of enforcement in insolvency, such as the lifting of the moratorium for landlords to forfeit leases or secured creditors to enforce security, or whether the test will be that the continued supply is actually critical to the company's operations, or whether there's a risk of the supplier facing insolvency if it's forced to continue the contract. And lastly, there is a question as to whether the new measures will have extraterritorial effect, so that a foreign counterparty is subject to these terms. The case law under section 233 and 233A has never really dealt with that. They've said there's a serious issue to try, so it's going to be a question to be determined whether you can force a foreign supplier to adhere to these terms or not. Next slide, please. And I think in light of these changes, which obviously are a significant amendment from the previous position, I think there's some practical considerations for suppliers and/or companies. I think three of the considerations that spring to mind are that suppliers need to be vigilant in monitoring the financial position of counterparties and acting swiftly in identifying defaults and/or warning signs. Secondly, contractual provisions need to be checked. For example, the insolvency trigger clauses. A number of agreements provide for insolvency events or an event of default to happen on the happening of an insolvency event. Questionable whether they should be triggered at an earlier stage. There's an opportunity to decide whether you want to change the contractual provisions or even terminate before. And thirdly, something that's been mooted about the consideration of framework agreements, which effectively govern the terms of a contract between the parties, but actually each supply or service is governed by an individual contract, which would therefore reduce the obligation to provide future supplies and/or potentially fall outside the remit of Section 233B because there is no ongoing contract. Can I have the next slide, please? And lastly, I just wanted to end quickly with a brief analysis on the suspension of wrongful trading. In the current climate, there are obviously a number of companies struggling and having to navigate through difficult and uncertain times. That therefore leads directors of companies having to manage their duties to act in the best interests of the company. However, when a company is in the zone of insolvency, which is considered to mean is or likely to be in the sense of probable insolvent, the director's duties shift to acting in the best interests of all stakeholders, with particular emphasis on the interests of creditors. And failure to have regard to those duties can lead to personal liabilities against directors. And wrongful trading is one basis for personal liability. And under the wrongful trading provisions, which haven't changed under the new legislation, a court can make a director personally contribute to the losses of the company if at some time before the commencement of the insolvency they knew or ought to have known that there was no reasonable prospect that the company would avoid insolvent liquidation or administration, and they failed to take every step with a view to minimising that loss. And the failure to minimise that loss and the causing of a worsening of the company's position is what known as wrongful trading. And the court apply an objective test as what a reasonable director would do in that particular situation. And given the pandemic and the need for urgent legislative reform, the ECA bill was introduced on the 20th of May 2020, and what the government said was the current crisis caused by COVID-19 pandemic means there's a great deal of uncertainty around trading conditions both in the immediate and longer term future. Directors are having to make decisions about the future viability of their companies and whether it is appropriate for trading to continue. The objective of the suspension of wrongful trading is to remove the deterrent of possible future wrongful trading application, so directors of companies which are impacted by the pandemic may make decisions about the future of the company without the threat of becoming liable to personally contribute to the company's assets if it later goes into administration or administration. And as a result, there was this introduction of Section 12 of the Corporate Insolvency and Governance Act, which suspended liability for wrongful trading between the periods of the 1st of March 2020 and the 30th of September 2020. The Act provides it can be shortened or extended by up to 6 months. At the moment, there's no indications it will be extended, but that may change. And essentially what the amendment provides is that when determining the contribution that a director should have to make to the company's assets, the court is required to assume a director is not responsible for the worsening of the financial position of the company or its creditors during that relevant period. And there are a few points to note, but the first point is that presumption for not being responsible for the worsening of the financial position rebuttable? If there was cogent evidence to show that a director had closed his eyes and the impact between the 1st of March and 30th of September made no difference, would the court change its approach? That's something to be tested. And how would the court approach if there was effectively wrongful trading before the 1st of March that continued between the 1st of March and the 30th of September? How would the court adopt that approach? And thirdly, despite all of this legislation being a result of COVID-19, the new legislation or the new amendments don't suggest that it can only be COVID-19 related. It suggests that the worsening of the company position could be anything related, and this suspension applies in respect of all aspects. And as Tom mentioned, lastly, one of the major flaws in this provision is that there's been no change to the statutory, fiduciary or common law duties of directors, and a breach of those duties can lead to breach of duty claims under the Companies Act, or what are also called as misfeasance claims, and can result in the personal liability of the directors. There is a statutory defence for misfeasance if the director can show that he acted honestly and reasonably, and that would have to be where a director can show that he's taken every step to minimise any loss, has a comprehensive paper trail of all decisions and the commercial rationale for entering into decisions. And the case law over time has suggested that the court don't adopt the benefit of hindsight. They need to be satisfied there is evidence that a director has been alive to his duties, kept proper and contemporaneous records with regard to every decision that's made, having regard to the interests of creditors at the forefront of any decision process. And as indicated above, the director's duties shift when the company is in the zone of insolvency. And that trigger point is often months before the realms of a company having no prospect of avoiding insolvent liquidation, which is the trigger point for wrongful trading. And therefore, just to sum up, whilst the suspension of wrongful trading provisions provides some comfort for directors, it can certainly not be seen as an exemption for directors' duties generally. Thank you.
Thank you very much, Prav, and thank you to, we have a slide here with some more information about Katten and their locations. I'll progress now to the, and there's the contact details of our panelists, Tom and Prav, but in the replay of this webinar on YouTube, all the details will be available in the video description, and that should be available this afternoon. So moving on swiftly to the Q&A, we've overrun slightly, so apologies for those who can't stay past 12 o'clock, but as I said, the full replay will be available on YouTube. We'll run through a couple of questions from the audience. We have one here from our viewer, John Kelly. Thank you, John. I feel like this is aimed more at you, Tom, so I'll let you have a go at answering it first.
No pressure.
No pressure, no pressure. We can open it up to the rest of the panel. So John asks, termination provisions in contracts are often triggered by an insolvency event, such as coming to an arrangement with creditors. Does this mean that the client cannot do this to a subcontractor without the subcontractor approval, that they are unable to proceed?
Sorry, could you just repeat that again? Sorry, I got part of it.
So John asks, termination provisions in contracts are often triggered by an insolvency event, such as coming to an arrangement with creditors. Does this mean that the client can't do this to a subcontractor without the subcontractor approval, that they're unable to proceed?
I don't know, Prav, how do you read that? This is probably a bit more of a Prav question as an insolvency lawyer and an interpretation. Prav? He's
Sorry,
left.
Tom. Yeah. So I'm just trying to be clear if I understand the question properly. So a company goes into insolvency, they want to vary the contract, and there's also the subcontractor. And if there is a variation to the contract, whether the subcontractor has to approve it or not.
I'm going to jump in on this. I think the question is asking probably from a intermediary perspective. So company A suspects that its supplier, company B, which is its subcontractor, because A may be within the supply chain as well, may be on the brink of insolvency or may go into insolvency, can company A still terminate its subcontract with company B, which is its supplier, in the way it usually did, because it usually, in construction contracts, would terminate either automatically or at its option for the insolvency of B, the subcontractor?
So it's a question the other way, whether the insolvent company has still got the ability to terminate or not.
I don't think the insolvent company.
Yeah. So I think what we're saying here, Prav, is that, you know, the subcontractor is going to fail. Can I terminate the subcontractor's contract? Can I terminate it rather than the subcontractor having this ability to carry on the arrangements with company A, even though they're the insolvency event. I guess with this one, it's looking at the detail, Prav. I don't have a definitive answer to that. My instinct is that you've got to be careful about anything in and around this sphere in view of the new provisions without looking at the detail.
Yeah, I think a lot of it turns on the contractual provisions, that's right. But on the face of it, I think there may be an opportunity to terminate.
So let me jump in as well. As a construction specialist, your JCTs and NECs will have traditionally always gave you the right to terminate the subcontractor at your option for the subcontractor's insolvency if you are the main contractor. I don't think that's changed. I think what's changed, as Prav described, is the subcontractor's ability to terminate on the main contractor's insolvency. That may not now exist, even if it does exist in the contract as a clause. This is what that legislation has changed. Am I right, Prav?
Yeah, that's right, yeah.
So I don't think John's got any problems in terminating those below him. It's if he wanted to terminate those above him.
Above him, yeah, on the supply chain, yeah, that's right, yeah.
What was the other question, Omar?
Thank you, guys. And John, I hope that answered your question. We have one more audience question. I believe this is anonymous. When a contractor seeks insolvency protection, can they still be terminated for failing to proceed with the works if contract provision exists? As often, insolvency will mean performance has been poor.
Can you repeat that?
Yeah, so that last part I missed.
Should I repeat that? When a contractor seeks insolvency protection and cannot be terminated, can they still be terminated for failing to proceed with the works if contract provision exists? As often, insolvency will mean performance has been poor.
Okay,
yeah,
so terminated on another basis, essentially.
Yeah, I think this obviously does fall potentially within this legislation. I think this is one of the areas that will have to be developed, because I can see the problem, because, you know, there would have to be a conversation with the liquidator, administrator or office holder to say, what are your intentions for performing this contract? If you're unable to perform this contract, that's going to create loss, and then that potentially falls into the hardship territory, where you would potentially have to make an application to court for directions to say, look, if this doesn't happen and there's not a continuation, I need to have the ability to terminate and seek alternative arrangements. And I think this is exactly the point that has to be navigated with this new legislation.
Okay, thank you, everyone. We will conclude there. Apologies again for overrunning ever so slightly. Thanks once again to our panel, Tom, Prav and Rob, for such an in-depth presentation. I'm sure you've cleared up a lot of uncertainty for our viewers out there. Just a reminder that more ECA information on business recovery can be found at eca.co.uk youtube.com/business-recovery, and a full replay of this webinar will be available at youtube.com/ECA live, and all the links and references we mentioned in this webinar, I'll try to include as many of those as possible in the description of the video. And with that, thank you everyone, and have a great rest of your day and a great weekend.
Thanks everyone.
Thank you.